Now, I think there are a few of you here today charged with no insurance. Listen along, it may save a few minutes. Mr. Ray, good morning.
Good morning, sir.
You're charged with no insurance. It's a 4-point offense, carries a fine, typically $500, though that could double if you've got a no insurance conviction within 5 years, or it could be reduced by 1/2 if you now have insurance but did not at the time. Possible jail term up to a year on that, though that would be unusual. The charge will be dismissed if you're able to show that the vehicle was insured at the time. You just didn't have the current documents, couldn't pull it up on your phone for whatever reason.
No, sir. I've been driving on a tag that's been out of date for 12 years. No insurance. And the only reason that I've come into your courtroom is because I was hit by a driver on the wrong side of the road, speeding. So I don't understand why I'm here, because I can read you some things that's in Colorado's laws, constitutional laws, and the Bill of Rights. So may I proceed?
You can plead not guilty
Okay, yes,
and
not
go to
guilty.
trial. I'm sorry?
Oh, not guilty.
Okay, do you want a court trial or a jury trial?
I'm going to be bringing a JAG officer, a judicial advocate general. So I'd want you to preside over it. So it's when you preside wrong, the ramification and punitive damages, and furthermore, what the JAG officer can refer you to a military tribunal, judicial hanging. I'd rather you preside over it.
Fascinating.
Yes. I'm a military brat, and there's some laws that y'all need to know about that are in the books. And I got them right here on my phone. So yes, I'd rather you preside over it, sir.
So you have a constitutional right to a jury trial. If you waive that right, you don't get to change your mind. It sounds like you're opting for a court trial.
Yes, because y'all are in the wrong. You can't force commerce. You cannot force me into commerce.
Ms. Owens, any objection to Mr. Ray waiving his right to a jury trial?
And
No, Your Honor. I mean, I think probably just a thorough advisement needs to be given, but otherwise, no.
You have the right to be represented by an attorney. If you waive that right, you'll be representing yourself. It's always advisable to have an attorney. You'll be held to the same standards as a trained attorney regarding your presentation of evidence. The court is going to have a motions deadline, approximately 30 days out. You can file any motion in advance of trial that you would like. Those have to be in writing.
Can I verbally dismiss it right now?
The motion to dismiss. Any objection, Ms. Owens?
Your Honor, the people believe that there are no grounds for the motion to dismiss, and also this is not the type of case that could be brought before the court on a motion to dismiss. The defendant has not cited any grounds for a motion to dismiss. The fact that he believes that the Constitution does not require him to have license, insurance, and registration, which is not founded in the law, is not grounds for a motion to dismiss. Thank you.
Civil or is this criminal?
It is a criminal charge.
Okay, then I'm going to compel the court
to
have the victim or the damage of property when we go to court.
You can file your motions.
Okay.
And we'll have your court trial on October 27th at 3 o'clock.
Okay.
They'll print that for you down the hall. That'll be a mandatory in-person appearance. Your motions deadline is going to be September the 11th. So any motions have to be filed in writing so the prosecutor has a chance to review those.
Before when?
On or by September 11th.
September 11th. Okay. What is her, may I get her name and may she say it? Can I get her to say it?
My name is Wendy Owens, Owens.
Okay, thank you, ma'am.
Thank you, Mr. Ray. They'll get your documents down the hall.
Okay, Sean Randolph, 26T317. Come on up, Mr. Randolph. And what would you like to do?
First of all, I'm here on a special appearance, not general appearance. I'm the representative of the account. I'm not the all caps fiction. I feel like this is kind of a waste of time. the state of Colorado erroneously converted a right to drive into a privilege and then charges a fee and tax to do that. So at some point, I'm confident that these cases will be resolved, but what do you recommend?
I can't recommend anything.
Oh,
I understand your position. I've had that position expressed to me quite a few times. It's
enroll
not
them by
not something I'm gonna grant if you want to file a motion, but based upon what I know, you can do what you want. But as of now, the motion, you're basically making a motion to dismiss for lack of jurisdiction. That motion is denied. This has been well
I
done. But you
object
don't
to the
argue with me when
denial.
I'm ruling, okay?
I'm
When
not
I
arguing-
talk,
I'm not arguing, Your Honor. I was just staying for the record. I was just trying to make sure that I got.
you are to be quiet when I talk, okay?
Mhm.
Okay, I'll let you talk in a second. So, I assume you don't want to talk to the DA then? It's up to you. You don't have to.
I prefer not to.
And that's fine. We'll go ahead and set this for a trial then.
Okay.
Do you want well, normally it would be a pretrial, or should we set it for a trial? Okay, we'll set this for a pretrial conference, and what would that date be?
If I waive the court, does it go to immediate trial or is it still a pre-trial conference?
It's still gonna be a pretrial conference. We're gonna follow our system here. Okay, we're gonna try and put it at the same date as whatever that other case is.
No, I don't want any convenience, sir.
We'll give you some anyway. Okay, August 11th at 10 a.m. with your other one.
Is he represented in that other case?
I'm representing myself.
Oh, pro se.
Okay.
Okay, gotcha.
And yeah. Oh, we do have a fingerprint order we're gonna give you.
August what?
August 11th at, what time was it? 10 a.m. 10. We're gonna give you a fingerprint order, and are there any,
For what is it for?
it's an order that requiring you to go get fingerprints.
I understand that, but I'm saying, which case is it attached to?
It's in this case, the driving under restraint case. Or excuse me, driving after revocation.
And what is the addition of the fingerprint order?
It's
Is that-
required by state law that you have fingerprints taken for identification purposes in case there's future violations or just the fact that it's a criminal offense.
I mean, is this common practice or is this specifically
Oh,
towards
no,
me?
this is certain cases, it's everybody.
No, and it's a traffic case that you send people to get fingerprinted?
Yep.
Regularly?
Yep.
Okay, I also just wanted to make a objection on the record.
Sure.
So,
I understand that.
yes, sir.
Okay, so I'll just pick up the order, comply with it, please. If you don't, there could be repercussions for you. And,
That was from here, huh?
Yes.
Oop, I almost stole the pin. That was a big one.
all right, well, let's not
Don't
go
wanna be
there.
doing any more court dates. We've got too many already, so.
Okay, August 11th, we'll see you then, 10 o'clock.
Sound good?
Thank you. Sean Randolph.
He's not being held on these cases. He's being held on something municipal, is my belief, but he is in
Okay.
custody.
Okay.
On SEAN.
SHAWN. Free trial on failure to provide proof of insurance, driving under restraint, and driving after revocation prohibited. All right, Mr. Randolph, my understanding is you're being held on other cases, but you do have these two traffic offenses, 26T 317 and 25M 540. Were you seeking counsel on these cases or not? Did you want the public defender to represent you? Or did you want to represent yourself?
I'm a little confused. What am I being held for right now?
Well, you're here, but not being held on these cases. Okay.
So where
I don't know what you're being held on.
I don't, Your Honor, unfortunately. I think I saw that on the sheriff's report. Give me one moment.
Oh, it's not ours. It's a Mesa County case.
Oh, it's Mesa County. That's what.
That's why we don't know what it is. So it's for an extradition of Mesa County. So whenever they come get you, you'll be out of here.
So was this?
This is what we talked about. One of them anyway, from a couple days ago. Remember when I did the? I remember you now. It took me a while. You look different, obviously. But this would be for the pretrial conference to see whether or not we can resolve this shorter trial. You don't have to have an attorney if you don't want to. It's fine.
And once again, Your Honor, I'd like to just go ahead and start off with just starting off that I'm here on special appearance, not on general appearance, that I'm not the all caps fiction. My name, I'm the living, breathing soul. Do you want a lawyer? I would like to represent myself, and I would like to,
Okay, we're just gonna schedule this for trial because that's the next step and that's what you
Okay.
want. Okay, I'm gonna do the motion for dismissal like I did last time you were here. We will schedule this when? Both. Well, is he entitled? Okay. I guess he is on the failure to provide proof of insurance. You gonna want a court trial or a jury trial?
I want a jury trial.
Okay. Oh, thank you. Okay, so Mr. Randolph, November 18th at 3 o'clock would be the start of your jury trial in both cases. At that point, or a little bit before, the DA will decide which one's actually going to go first. Okay, because they have the burden of proof. Any pretrial motions that you want to file need to be filed by September 7th. There will be a motions hearing if things are filed on October 1st. And there's a pretrial readiness conference that'll be held at 3 p.m. on Tuesday, November 10th. This will be in a written order on both cases, so you'll have these dates. All right.
What?
And so we will see you back here on the 10th, unless if you file a motion and if you want the motion to dismiss to be heard more formally, you need to file a written motion on both cases. And that we'll see it on the hearing on the happens. But right now you're being held for Mesa County and they're just going to deal with you. We're not holding you. Okay. Any questions? All right. And do you want me to advise you in terms of your right to have an attorney? Because I haven't done that.
If you'd like.
Well, I don't really care. You do have the right to have an attorney. You need to understand.
My main concern, Your Honor, I think would come to was my accuser. And if there's no victim, then there's no accuser, then there can be no person I can get on the stand that I can cross-examine and determine how I have harmed them, how I have disparaged them. But that's I'll cover that in my motion.
Yeah, that would be the motion here. In any event, you do have the right to have an attorney. You need to understand that you do have a right to represent yourself. An attorney can be useful.
Because otherwise, if I have a public defender, then Your Honor is on the bar, paid by the state. The district attorney is on the bar, paid by the state, and my attorney would be on the bar and paid by the state. That would create impossibility for me to have a fair hearing. And I don't understand how everybody can be paying to the bar and also paid by the state. And I'm the only one that I'm the only one that is risking anything. There's nobody else that has any equity into it's all,
that may be
all the equity would be.
That may be also. Okay. But I am going to tell you, criminal law is somewhat difficult. And if you want to have somebody appointed to advise you, I can also do that. As an attorney, it wouldn't be the public defender, it'd be somebody else.
Could I have somebody appointed as a co-counsel possibly, or some kind of?
No, it would just be an advisory decisions. You could ask them for advice, but that would be it.
You could do that?
Well, I would appoint somebody to do that.
Okay.
As advisory counsel.
So I could have advisory counsel and still represent myself?
To sit with you and still represent yourself, yes.
Okay. Could you do that?
I can do that. We'll have to see who that'd be, but we'll have the clerks appoint advisory counsel to sit with you during the trial and during the hearings. As an attorney, it wouldn't be the public defender; it'd be somebody else.
Could I have somebody appointed as a co-counsel possibly, or some kind of?
No, it would just be an advisory decisions. You could ask them for advice, but that would be it.
You could do that?
Well, I would appoint somebody to do that.
Okay. As
advisory counsel.
So I could have advisory counsel and still represent myself?
To sit with you and still represent yourself, yes.
Okay. Could you do that?
I can do that. We'll have to see who that'd be, but we'll have the clerks appoint advisory counsel to sit with you during the trial and during the hearings.
Like a babysitter?
Okay?
All right.
And,
There he is right there,
well,
Mr. Sims.
Could be. it could be. And actually, I'm telling you this, I know this is how it works on felonies. I think it works the same on misdemeanors. So, I'll make sure that's correct, but, we will appoint somebody to be advisory counsel.
That way the procedure and everything, the decorum of the court is still somewhat intact, right?
I hope so. That's the plan. Okay.
And Your Honor, if I may, he needs to contact our office to receive discovery. We'll file a notice with the court regarding that discovery availability, but he would need to reach out to our office.
Okay. So the police report saying what the evidence is, who their witnesses are, that sort of thing. You can obtain that from the DA's office, but you have to ask them for it. So once you deal with what's ever going on in Mesa County, make sure you do that. Okay.
Sure.
All right. Well, good luck.
Thank you.
The next case is 2025 M78, People versus Douglas Tooley. May I have the appearances, please?
John Clothier for the People, 61076.
Hi, Mr. Tooley. I can see that you are on the screen. Can you turn on your camera and your microphone, please? There we go. Good afternoon, Mr. Tooley.
Good afternoon, Your Honor.
All right, we are here today because we were waiting to see if we were able to find you alternative defense counsel. We are still waiting for confirmation of that attorney to represent you. And so we're not able to move forward today with anything just because we're waiting for that counsel to be identified and then enter his or her appearance. So I'm going to set this over for 2 more weeks and we will continue working on getting you appointed counsel. Okay?
Has there been a Burger hearing?
Pardon me?
As I understand the process, there would be a Burger hearing prior to the assigning of alternate defense counsel.
No, we actually had the public defender filed their motion and I granted their motion. And so now we're in the process of appointing it because there had already been a determination that there was a conflict, I think in another jurisdiction.
It was district court in this jurisdiction, in this county.
Yeah, I think it was you had filed the motion, sir, asking the court to adopt the finding from case number 25 CR 14. I went ahead and permitted the public defender to withdraw based on your request. And so now we are looking for counsel to represent you. Unfortunately, we have limited attorneys on the Western Slope. And so it's taking some time to get appointed counsel to represent you.
I do not recall submitting a motion. We may have discussed it, but
let me see here. Actually, I think it was Miss Farkash on your behalf that had filed the motion. And based on that motion, she had asked this court to take the findings that were made in your criminal case, 25 CR 14, which allowed her to withdraw in that case and made them equally applicable to this case. And so I have adopted that, entered an order, and now we're waiting on counsel to be appointed.
Salently, I have never seen any of those documents, which would be consistent with the issues I presented in 25 CR 14, which I've not fully presented in 25 CR 14. Brent Martin, who was just on the call on the WebEx, did accept the alternative defense counsel appointment on that case on July 24th, but I have not heard from him.
Sure.
He was, here today.
Yeah, so Mr. Martin only takes the felony appointments and you are not charged with a felony in this particular case. And so therefore, Mr. Martin cannot represent you in connection with this case here. I agree with you, sir. That would have been ideal to have the same attorney involved with both cases, but unfortunately that's not the way that it's going to be played out. So we are going to find you new counsel and I am going to reset this in 2 weeks and ask that you come back on video again in 2 weeks so that we can hopefully have new counsel involved at that point. And sir, I was looking at our record, and what happened when I entered that order, so simultaneously with the order, it goes to your previous counsel, and it's your previous counsel's responsibility to make sure that you get a copy of orders that the court entered. So I apologize that Ms. Farkash did not get you an order showing that you were going to have new counsel appointed. And certainly, if you want to give us your address, we can make sure that you get a copy of the court's order.
My address should be correct.
All right, let me just look at the file, and I'm not gonna say it out loud, so that it's not on the record. But I'm showing an address on Mountain Village Boulevard. Is that correct?
That is not correct. And I believe I've corrected all of these previously.
All right, sir, we can do one of two things. You are welcome to call the clerk's office after this hearing and give them your address. We will enter that in the system so that you're not putting it in a public record. And then we will send you a copy of the court order. And then mailings will come to you directly until such time as the public or the alternative defense counsel enters their appearance.
I've also filed a notice of appearance on this as well, which is an issue we can, as what I'm calling second counsel, which is an issue we can anticipate addressing at some point. And I can double check the address. I'm using a PO box now, and I'm fine with putting that in the public record.
Okay, what's your PO box?
PO box.
All right, sir, I can only consider matters that are in case number 2025 M78. That's what we were set to do today, and that's the case that is in front of county court at this time. There is no outstanding motion at this time. So just wanted to make sure that you are aware that there's no outstanding motion in the county court case. So any other issues that you have to take up, I'm assuming they're in the criminal case that is in front of Judge Yoder.
I have 2 additional points.
Well, sir, since you have requested counsel, let's wait until you have counsel involved in that case, and then any additional issues that need to be taken up, your attorney can file those with the court and follow the appropriate process. All right,
there are substantial procedural problems. Both of these cases are retaliation for my calling to account Marshall Comte, who was present at the most significant instances in both of these cases. And that previous case has been withdrawn.
All right, Mr. Tooley, I'm gonna stop you right now because anything that you do say on the record is a statement that can be used against you, even if you think that it's a statement that you don't care that particular statement is being used. While you have requested counsel, sir, I can only take up matters that come directly from your attorney. So I'm not going to take up any other issues at this time unless you are of the mindset that you want to represent yourself.
We'll go into this in more depth with counsel, but I'm also not withdrawing my right to a speedy trial with this Berg Road hearing, as was done in 25 CR 14 without my consent.
All right, we're only discussing right now, sir. There's no speedy trial issue right now because you have not entered a plea. We are only here on 2025 M78. So any issues you have in your other criminal case need to be raised directly in that criminal case through Mr. Martin and through Judge Yoder.
I understand your intent, but these cases are substantively linked with procedural flaws and abuse of process and malicious prosecution there in San Miguel County prior to your arrival, replacing former Judge Sean Murphy.
Well, I am going to set this for September 1st at 2:00 PM. Ideally, we have counsel in place for you at that time, and I will look forward to anything that your newly appointed attorney wants to file so that he can address issues of concern that you have. Is there anything further we can do today, Mr. Clothier?
No, Your Honor.
All right, September 1st at 2:00, Mr. Tooley, and we'll get a copy of that court order sent to your PO box.
That's 3 weeks.
I'm setting it for 2:00 PM on September 1st because I want to make sure that I'm the judge hearing your case, and I will not be here in 2 weeks.
All right. Thank you, Your Honor.
All right. Have a good afternoon, and we'll see you on September 1st.